Welcome to the Deep Dive. Today we're tackling a really significant legal development in India. It's something with direct relevance, I think, for your UPSC preparation. Definitely for the mains exam, but maybe some potential for prelims awareness too. We're diving into the complexities around, well, sexual intercourse based on a false promise of marriage. And our main source for this deep dive is a very insightful analysis recently published in the Hindu.
Exactly. And our mission today really is to go beyond just the headlines. We want to properly dissect the legal landscape here. We'll be focusing hard on the introduction of Section 69 in the new Bharatiya Nyaya Sanhita, the BNS, looking not just at what it says, but, the rationale behind it, potential problems, pitfalls maybe, and also how Indian courts have actually handled these very sensitive situations historically. So
Yeah.
we'll be referencing the new laws, the BNS, the old IPC for comparison, and definitely some key Supreme Court and High Court judgments to give you that really in-depth understanding you'll need.
Okay, right. Let's unpack this then. The absolute core here is this Section 69 of the Bharatiya Nyaya Sanhita, 2023. So this new section, it explicitly makes it a crime to obtain sexual intercourse using deceitful means. And it specifically calls out a false promise to marry as one of those means. Now, what makes this really stand out, as the Hindu article points out, is that the old law, the Indian Penal Code, or IPC, didn't actually have a specific standalone section that addressed this quite in the same way.
That's right. It wasn't singled out like this. And under this new Section 69 of the BNS, the punishment prescribed is imprisonment for up to 10 years, plus a fine. Now, it's really important for you to note, especially thinking about your exams, this penalty is actually less severe than the punishment for rape under Section 63 of the BNS, which, is the successor to the old Section 375 of the IPC. And as you said, while this new section seems like it's trying to address a specific concern people have, its actual introduction onto legal books has, well, it's definitely stirred up quite a bit of debate.
Yeah, and here's where it starts to get really interesting and maybe a bit complicated. There's a pretty strong argument being made that Section 69 might actually be, well, redundant, unnecessary. You see, Section 28 of the BNS, it still defines consent. It carries over that definition. And crucially, that definition still includes consent given under a misconception of fact. Now, legal interpretations, even before the BNS, had already established that a false promise of marriage could fall under this misconception of fact.
Precisely.
Which potentially means such cases could already be prosecuted as rape under the existing framework.
That's the crux of the argument. The idea is that if the woman's consent was only given because she genuinely believed there was a promise of marriage, which the man never intended to keep, then her consent was based on a misconception of fact induced by him. And under Section 63, that could vitiate consent, potentially making it rape.
So if that mechanism already exists,
Right.
why Section 69?
Well, that's the million-dollar question, isn't it? Perhaps there was a feeling, a societal push maybe, to specifically acknowledge this kind of breach of trust in relationships. But as we're seeing, the way it's been done raises some pretty significant legal questions. There's this potential overlap, this redundancy issue. If the existing definition of consent through misconception of fact already covers these situations, then does Section 69 actually offer a necessary, distinct legal tool? Or could it maybe inadvertently create confusion, or perhaps even dilute the seriousness by treating it as a separate, lesser offense compared to rape?
That's a critical point. So to really grasp this for your UPSC prep, we absolutely need to look at how the courts, especially the Supreme Court, have been interpreting these cases over the years, because they've been trying to draw a line, haven't they? A line between, say, a genuine promise that unfortunately gets broken later for whatever reason, and a situation where the person never intended to marry from the get-go. It was deception from the start.
Absolutely. And the judiciary has been grappling with this distinction for a while. We can see this in some really key judgments. Take the landmark case, Anurag Soni v. the State of Chhattisgarh back in 2019. Here, the Supreme Court made it quite clear. They said if a promise to marry was sincere at the time it was made, but then later circumstances meant it couldn't be fulfilled, that situation doesn't automatically become rape. The crucial thing the courts consistently look for is the accused's initial intention. Did they genuinely intend to marry the woman right from the beginning, or was it a lie?
Right, so that focus on the initial intent is paramount. And it wasn't just a one-off finding, was it? Think about the Rajneesh Singh at Soni v. State of UP case from 2025. In that instance, the court actually quashed the case entirely, and it involved a very long-term consensual relationship, I think, so something like 15 years.
15 years, yes.
And the fact that the complainant had apparently even publicly presented herself as his wife, that really weakened the claim of rape based on a false promise after such a long time of, well, seemingly voluntary involvement.
Exactly. The court noted the lack of evidence pointing towards coercion or deceit stretching over such a prolonged period. It just didn't fit the typical false promise leading to sex narrative after that length of time in public presentation.
Okay.
And then there's another case that narrows the scope even further. Abhishek Arjaria v. the State of Madhya Pradesh, also from 2025. Here, the High Court ruled something quite specific. It said that if a woman was already married to someone else, her consent to a sexual relationship based on a promise of marriage from a third party wouldn't be considered invalidated by a misconception of fact. The reasoning being, presumably, that her existing marriage complicates the idea that she could have genuinely believed an immediate legally valid marriage was possible or the sole basis for consent. So again, it shows the courts are really digging into the specific circumstances.
So putting all that together, the courts are already doing this very careful, very detailed examination. They're looking hard at intent, at deception, at the context, all within the existing framework of consent and rape laws. Which brings us back to the question you raised earlier. What extra work is Section 69 actually doing? What unique purpose does it serve if the courts are already managing this complexity?
And that really feeds directly into the core redundancy argument we mentioned. By creating this separate offense, Section 69, which carries a lesser punishment, it arguably creates a kind of legal inconsistency. If, as we've discussed, sex under a false promise can already be prosecuted as rape via the misconception of fact idea in Section 28 and Section 63, then why introduce this separate, less serious category? You could even argue, couldn't you, that having a lesser offense might inadvertently encourage prosecutors to go for the Section 69 charge, as it might be seen as easier to prove than rape under Section 63, even if the facts could support the more serious charge.
That's a potential unintended consequence, definitely. And there are also these constitutional concerns being flagged up, right? Particularly around the lack of something called a non-obstant clause in Section 69. Now, for those of you preparing for exams, maybe not deep into legal jargon yet, think of a non-obstant clause as saying, this rule applies despite any other potentially conflicting rules. It gives it overriding power.
Like a trump card, yeah.
Exactly. And its absence in Section 69 is a bit worrying, because it leaves it unclear whether Section 69 is meant to take precedence over other laws, especially Section 63, the rape law, if there's an overlap or conflict in a specific case.
Precisely. Without that clear statement of priority, there's a genuine risk. Section 69 might face challenges on constitutional grounds, particularly under Article 14, which guarantees equality before the law and equal protection of the laws, creating a separate, less serious offense for actions that could arguably meet the definition of rape. It does raise fundamental questions about treating similar situations differently based on, well, which section is applied? Is that equal treatment? Is it legally consistent? Unless the legislature steps in to really clarify the relationship between Section 69 and Section 63, maybe by amending Section 63 or adding specific clauses, the actual validity and the practical enforcement of Section 69 remain, frankly, quite uncertain.
Right. So with all this legal sort of murkiness, it seems the courts are already kind of voting with their feet in a way. We're seeing this trend you mentioned, courts quashing FIRs, first information reports, in these kinds of cases more often when that clear deception isn't immediately obvious.
That's a really crucial point about what needs to happen on the ground, procedural prudence. There's a strong case to be made that the police need to be extremely cautious here, perhaps conducting more thorough preliminary inquiries before registering an FIR and launching a full investigation, just to really ascertain if there's enough prima facie evidence of a genuine, cognizable offense, specifically the element of deceit from the outset. This kind of careful initial assessment could really help. It could prevent individuals from facing undue harassment or the trauma of a criminal case based on what might ultimately be seen as a relationship breakdown rather than criminal deception.
And it would also ease the burden on the courts, presumably.
Absolutely. Reduce the number of cases reaching the courts that are later found to lack the necessary ingredients for a conviction under either section. The underlying principle should be that criminal law isn't used as a tool to settle personal scores or navigate complex relationship disputes unless there's clear, demonstrable evidence of criminal conduct like deception or coercion.
Okay, so let's try and bring this all together, especially for you listening, the UPSC aspirant. What's the takeaway here? Well, Section 69 of the BNS, it might have been introduced with a specific intention, perhaps reflecting concerns highlighted in media like The Hindu about breach of promise. But its introduction seems to have maybe inadvertently created more legal questions than answers. The existing legal definitions, particularly around consent and misconception of fact, combined with how the judiciary has been carefully developing its understanding in these sensitive cases, It all strongly suggests that Section 69, as it stands, might be largely redundant and potentially even constitutionally questionable due to the Article 14 concerns and the lack of clarity vis-a-vis Section 63.
Exactly. At the end of the day, a more effective path forward probably doesn't lie in creating new, potentially overlapping or problematic provisions like Section 69. It more likely involves continuing the trend of judicial vigilance courts carefully scrutinizing the facts. It involves careful, considered policing those preliminary inquiries we discussed, and, perhaps most crucially, much clearer legislative guidance to ensure consistency and avoid these ambiguities. It's really about refining the application of existing principles rather than adding layers of complexity.
So here's a final thought for you, the listener, to mull over for your preparation. Given these complexities, these potential contradictions we've discussed, how does a deeper understanding of these legal nuances, the tension between Section 69 and 63, the role of judicial interpretation, how does that inform your analysis of broader social justice issues?
Yeah, and what about the role of law in regulating personal relationships? What are the wider implications when the law creates specific, perhaps lesser, offenses for actions that might already fit under existing, more serious categories like rape? Where do you draw the line?
Lots to think about there. This has been our deep dive into the legal complexities surrounding false promises of marriage in Section 69, drawing heavily on analysis from the Hindu. For all of you preparing for the UPSC exams, we really hope this detailed discussion is giving you some valuable insights for your prep.
We hope it helps you connect the dots between legal changes and their societal context.
If you found this useful, please do hit like, subscribe to our channel for more deep dives like this, and definitely leave a comment below. Let us know your thoughts, your questions on this topic.
Your engagement genuinely helps us figure out what topics are most relevant and useful for you.
Absolutely. We're actually thinking about maybe tackling recent shifts in global economic policy for a future deep dive, so keep an eye out for that. And let us know if there are other areas you'd like us to explore.